Hello, everyone. Hello, welcome. Thank you so much for joining me. I'm so glad to have you. Before we get started, I just want to make sure that everyone can hear me okay. If you can just enter in the chat. If you can hear me, just go ahead and enter that real quick so that we are sure that we are good to go. Okay, great. All right. Well, my name is Seren Adams. I am founding attorney here at Adams Law Office. Thank you so much for joining me for our workshop on leaving a legacy instead of a mess. We fill these to the brim with lots of information you need about estate planning, but there really is no way a single workshop could cover everything there is to know. Each person's situation is unique. There's no one-size-fits-all solution. So that's why we provide a complimentary consultation to each of our workshop attendees with one of our awesome attorneys. I always make sure to leave enough time at the end for questions and to give you the information on how to get your complimentary consultation scheduled. And also just to let you know what to expect, we'll do some brief introductions and then start with some basic estate planning terminology. And get into some more sophisticated planning techniques using revocable and irrevocable trusts. And if you choose to move forward with planning and would like Adams Law Office to prepare your plan, I'll also go over details about our pricing and our process. We don't like to hide the ball when it comes to fees. We're very upfront about what things cost, mainly because we know the real cost to your family of putting this kind of thing off and leaving them without a plan in place to take care of them if you're not there. So we set up our entire process really to keep you on track and moving forward. We already know we're speaking to people who know the importance of this, otherwise you wouldn't be here. There are plenty of other things you can do with your time. So my goal is that at the end of this, you'll have all of the tools you need to be able to make the best decisions for your family and for keeping them out of court and out of conflict. So let's get started. I'm going to go ahead and share my slides with you. So please let me know in the chat if you can see them. Let me go ahead and share my screen. Okay, hopefully that is showing up okay so that you can see that. Just let me know in the chat if you can see that. Okay, good. All right, so some quick housekeeping details. If you can please make sure that you have the workbook that is available on the handout materials. So you should be able to download that. If you can also make sure that you have a pen handy, you can jot down, if you printed that out ahead of time, the workbook, you can jot down any questions that you have that come up. The workbook actually follows along with the slides, so you don't have to write down any of the slide contents, but you can just write down your questions as we go. I do take questions at the end of the workshop so that we can get through all of the material first, and hopefully that works for everyone. But I do know from experience, if we start taking questions in the middle, we never get to the end. So we take questions all at the end. So please write your questions down so that we can get to those. Also, if we don't get to all of the questions at the end, you can also make sure that you write them in your workbook, and you can bring that to your consultation with the attorney, and they can also go through questions at that time with you as well. I also recommend turning off any distractions so that you have this dedicated time to be able to focus on the material. It does get very complicated at points of this, so being able to focus on this really helps to be able to do that during this time period. All right, so I always like to start off with this big picture concept I've kind of come to understand over the years of doing this, which is that estate planning is not actually about you. It's really about the people that you love the most. That's why you're planning. That's also why we want to make sure that your plan actually works the way that you intend it to, so that those same loved ones will know that you lived up to that promise, that I took care of it when the time comes. There's actually a spot in the workbook where you can actually write down the names of the people that you're actually planning for. It's helpful to keep them in mind as we're going through some of the material. The people that I love the most and why I ended up doing estate planning. Quick introduction about me. I've been practicing in the area of estate planning for over 20 years now. This is my family. I graduated from George Washington University Law School, was recruited to Ernst & Young right out of law school to their national tax department, where I was helping big companies avoid taxes. I immediately felt like I was in the wrong area of law, but I was initially actually introduced to estate planning because of my family, and all of them had me prepare their estate plan right after I graduated from law school, as if I knew what I was doing right out of law school, which I did not. So I was using right out of law school the form documents that the Bar Association gives new attorneys and general practitioners to use. And those form documents, the problem with those is they lead you right into probate court, which none of my family wanted. And then I had my son a couple of years after law school, and I did our personal estate plan, and that really amplified my concerns about those form documents. There's really something about creating those documents for your personal family, for my mom, my sister, her kids, my son. It really begins to kind of freak you out when you see how those plans really don't work. I remember going out of the country, broke out in stress hives, thinking of all the things that were going to go wrong in my plan, the things that were not addressed in those kinds of form documents. I actually came back from that trip, refocused my entire career, really focused all of my energy at that point on estate planning. I left Ernst & Young, started my own firm, really with the goal of helping real people. Instead of these big companies for them to save taxes, really my goal was to really continue to perfect estate planning, figuring out all of those issues that were amplified for me, and really try to customize estate plans to make sure that families, that we're keeping them out of court and out of conflict. So the difference with what we provide is that it's really a proactive plan that leaves your loved ones with legal and financial clarity, and also support in making wise decisions. And they have a trusted advisor and the documents and guidance that are necessary, so that if you become incapacitated or after you pass away, your loved ones know what to do, and they know what you have and how to find out what you have, and also have someone to turn to so that they aren't lost and confused while they're grieving. On top of that, when legacy planning is done well, it really supports you living with and having more financial legal clarity during your lifetime, and really being able to create a legacy that is worth leaving. So as my firm started growing, I started meeting these awesome ladies who had such similar experiences in their careers, really searching for meaning in what they did. This is our team of attorneys, and I truly feel blessed that these ladies have linked arms with me and joined the vision of serving families by making sure that legacies are preserved and not lost, and that each generation is not starting from scratch. They're really, truly dedicated to making that kind of difference in the lives of our clients, and really they're awesome at communicating complex principles in an easy to understand way. So that is one of the gifts that each of them has, which is awesome. And then we have our support team. We are blessed to really have a team who are all just a wonderful group of people passionate about serving others. That's really the quality that we look for in our team members, and it's truly rare when you find someone who has that passion, and it's a blessing to work with each of them. We all kind of just enjoy how much of a difference that we get to make in the lives of the families that we get to serve. So along the way, we also received a few accolades, which is also very fun when you're doing something you enjoy anyway. So it's a little bit about us. I always feel it's important that you know who you're hearing from. So let's jump into the content so you can understand what it is that we're talking about when we're talking about estate planning. So getting some of the terminology down. When we are talking about an estate, what we mean is all of your stuff: personal property, real estate, financial accounts, and life insurance. And it's really important to note that life insurance is included in your estate because it's often one of the largest assets, and the IRS and the state include it in your estate size when they're calculating estate taxes. Estate taxes are also known as death taxes. They're assessed on your estate and your assets after your death, but before those assets are distributed out to your beneficiaries. So the federal estate tax, right now it's very hefty, it's 40%. But it's only assessed on estates over 13.9 million in 2025 and 15 million in 2026. So most families won't have to worry about this unless the law changes, which it could. It actually changes all the time in terms of estate taxes. Each administration has different priorities about this. And this is one of those areas that historically has been the target for adjustment. So it can change. The Maryland estate tax, this is also something that can change. The rate is approximately 16% here in Maryland, and it's currently assessed on estates over 5 million, but was just targeted by the governor to be reduced to 2 million. That was rejected by the legislature, but again, these things are constantly in flux, so it should be monitored. If your estate is higher or in that higher tax range, this is something you should be keeping an eye on. It's a key thing in your estate planning to know your estate size and the property that's in your estate so that your estate planning attorney will know what type of estate plan to put in place to protect those assets. You also want to be sure that you have a list of the property in your estate and having that accessible to your loved ones. If something happens to you, you need to know that they know all of those assets so that nothing is lost. There's over $1.6 billion right now in Maryland's unclaimed property accounts. You certainly do not want any of your hard-earned money ending up there. I say it's where money goes to die. You do not want your money ending up there. So another thing that is important for you to know and also to avoid is the state intestacy laws. If you pass away without any kind of estate plan in place, the laws that are going to govern what happens to all of your stuff, those are called the intestacy laws. And most people have assumptions about what would happen when you pass away. But it's important to know the reality because most of the time it's different than what you would have wanted. For example, most couples assume that if something happened to one of them, the other is going to inherit everything. But for example, under Maryland law, that is not always what happens. If, for example, you have you're married and you have minor children, meaning your children are under 18, then your spouse is going to get half of your estate and your minor children, the kids under 18, are going to get the other half. And what that actually means is that the court has to get involved, assigning a guardian for your minor kids' property. If the court ends up picking a third party, meaning somebody other than the parent, they can charge fees on a monthly basis just to be looking at a bank account. So less money is going to be going to your kids. And then what is even worse, when your child turns 18, they will inherit whatever is left in that account without any kind of supervision because they will be then considered an adult. If you think back to when you were 18, that's probably the worst possible time to inherit a lump sum of money. Even for the most responsible 18-year-old, that is the time period when, especially if you're grieving for a parent, that's the time period when your peers are going to have a high influence over what you're doing. So most likely, if you're thinking about what all of your friends want to do with a lump sum of money, it's probably trips or consumables, all sorts of things other than what you probably are intending for to happen with those funds. If another example, if you're married with adult kids, but your surviving spouse is not the parent of those kids, then that surviving spouse gets a spousal allowance and half of the estate, and the kids get the other half. If you have no living heirs or stepkids, the Board of Education gets your assets. So clearly there's always a better plan that you can make other than the state intestacy laws. Always a better plan that you can do. So in estate planning, we're often trying to avoid certain things from happening. We think of these things kind of as modern day grave robbers. The first would be probate. We'll go over that shortly, but another one of these things that you want to be avoiding would be mismanagement of your property. And this can happen if you're incapacitated and you don't have the proper documents in place to protect yourself and your property. It can also happen if you don't leave the proper instructions for those people that you're leaving property to after you're gone. Another thing to avoid would be family drama. I think we can all say nothing can cause more pain than those close to you hurting you emotionally, physically, financially. But there can also be family drama from just not preparing properly and leaving a mess for people to clean up. Finally, we also want to avoid running out of money. And that can happen, of course, if we don't save enough to retire and things like that. But a primary way families end up running out of money nowadays is by using it all up to pay for the high cost of long-term care. Long-term care costs can cause the loss of things like a family home due to the Medicaid liens, or the flat-out sale of a family home to pay for the cost of care, or the spend down of assets to qualify for Medicaid. We bring Medicaid and long-term care up in all of our estate planning consultations because long-term care costs, they can seriously just derail an estate plan or a financial plan. So let's spend some time just looking at this briefly. Most studies are consistent in showing 1 in 2 people will need some type of long-term care. Alzheimer's is growing at a really alarming rate. There's more than 55 million people living with Alzheimer's or other types of dementia worldwide. And there's an estimated 7 million Americans living with this. Studies are also indicating that some people live as long as 20 years after diagnosis of Alzheimer's dementia. And also, according to the Alzheimer's Association, caregivers are at a really high risk of developing their own serious health problems or worsening any health problems they already have just from the stress of caring for somebody with Alzheimer's. So lots of issues developing out of this. The average cost of nursing home care, this is the sticker shock of it all. Average cost of care, over $11,000 per month for nursing home care. That's over $138,000 in Maryland, and even worse in DC, over $174,000 per year that you're talking about for long-term care. And we get a lot of clients who say to us, I'm never going to end up in a nursing home. My family is going to take care of me at home. Hopefully that is the case, but even private care at home is really costly because family members, they usually have to work as well. So somebody's got to be able to stay with you. So private care, if you were hiring a home health aide, and I had to deal with this just recently with my own mom who lives with me, average cost is about $29 per hour. That's about $60,000 if you're just looking at 8 hours a day. If you're looking at that for a year's type of situation, $60,000 per year if you're looking at 8 hours per day. For full-time care, that's about, and we're talking 24 hours of care per day, 24 hours cycle, $254,000 per year for full-time 24-hour care. Insane amounts of money. And how are most families able to pay for these kinds of crazy healthcare costs? So payment options include things like Medicare, but Medicare will only pay for the first 100 days of long-term care after a hospital stay. It is not the source of payment for nursing homes. Medicaid is, but Medicaid, you have to qualify for it to pay for long-term care. In Maryland, for example, you have to, in order to qualify, you have to have $2,500 or less in assets in order to qualify for Medicaid to pay for your long-term care. So basically dirt broke. You can also have another option of using your savings to pay, which is not a great option because you have to use it all up. Another option would be purchasing long-term care insurance, sometimes a very costly option though. Another option is implementing a legal plan to protect your home and savings. But often what happens is a combination of all of these options, because by the time you're looking at this, often all of these things have to be implemented. But we'll talk more about the legal plan that you can put in place to protect property from long-term care costs. But let's flesh out some more of the basics in terms of other things you need to know about first. Let's talk about probate. So if you pass away without an estate plan in place, or if you pass away without the proper estate plan, like if you just have a will, your estate has to go through probate to get distributed to your beneficiaries. That last part is actually worth repeating because it's one of the major myths about estate planning. If you just have a will, your estate has to go through probate to get distributed to your beneficiaries. So probate, I like to describe this basically as suing yourself after you've passed away for the benefit of your creditors. So it really doesn't make much sense to do this. If you can avoid it, you should. The primary issues with probate, and there are quite a few of them, but one of the primary issues, it's an administrative burden on your family members. There are specific documents containing all sorts of information that have to be submitted to the court by certain deadlines, all at the worst possible time for somebody to have to go through doing all of that, because this is at a time period where they're mourning the loss of a loved one. So dealing with all of those types of deadlines and court documents and the requirements of those at that time is usually the worst timing. It's also costly. In Maryland, the costs are actually capped. They're capped at 3.6% of the estate size, which is good that it has a cap. But for example, if you are looking at an estate valued at, say, $500,000, which is actually kind of low in Maryland given the cost of homes in this area, the cost for that size estate, $500,000, is going to be approximately $20,000 when you're looking at that size of estate for a regular estate in Maryland. That's 4 times more than the cost of a good estate plan, by the way. It also, going through probate causes a delay in the distributions. So it's a minimum time period of 6 to 7 months to go through the probate process. Required time period of 6 months, and then you have to have if you're doing a regular estate, a 20-day time period where you have to wait for an account to get a time period where you're waiting for the account after it's approved, a waiting period that's mandatory. So adding all of that in and any kind of mailing periods, you're looking at a minimum of about 7 months. The national average is about 18 months. So that 7-month time period, and most estates in Maryland are going to take about 12 months when you're looking at what the average is in this area. So we're probably doing pretty good when you compare that to the national average of 18 months, but it's still such a long delay when you're looking at distributing things to your beneficiaries. It's also public. So predatory individuals can easily find out who's inheriting, their contact information, how much they're inheriting, and when. So again, it's putting your loved ones in a situation where it can be completely avoided and they're really vulnerable at this time. So if it's something that you can avoid for them, really you should. Probate, and especially intestacy probate, which is the kind where the state law, rather than you, is deciding who gets what, they can be completely avoided with the proper estate plan. So let's look at a few different ways that you can avoid probate. We have joint tenancy ownership, beneficiary designations, or by transferring assets to a trust. So there are pros for all of these options, but the first 2 options also have some major cons, which is why trusts are actually the recommended way of avoiding probate. So most people are familiar with joint tenancy just through owning either real estate or cars jointly with somebody. If one of the owners dies, the other person inherits that property automatically. The property doesn't have to go through probate to be distributed. It's distributed automatically to the other owner. The issue with this type of ownership is when the last owner passes away. In order for that asset to go to anyone else, it has to go through probate. Even if that last person's will states where they want it to go, eventually it still has to go through probate to get to that person. Because remember, a will has to go through probate. Then you have beneficiary designations. So again, most people are familiar with beneficiary designations as well, on things like life insurance, IRAs, other accounts. After the owner of these types of assets passes away, the asset goes to the beneficiary directly without going through probate. Issues with this as well. Issue number one, if the beneficiary designation is not kept up to date. So like having a parent listed instead of a spouse, or someone you no longer want to benefit, like somebody you've divorced or something like that, or somebody you no longer have a relationship with, listed as a beneficiary still on an account. What if the beneficiary is no longer alive? That means that if somebody passes away, the beneficiary they have listed is no longer alive, that asset has to go through probate in order to get distributed to anyone else. So again, we're back in the probate area. Another issue, what if the beneficiary is a minor, or they're incapacitated, or just irresponsible? Any of these scenarios have major issues. If the beneficiary is a minor, for example, those assets go into a custodial account, just like the scenario we talked about before, and then that beneficiary receives the entire asset when they turn 18. And again, not a great time period for somebody to receive a lump sum where they're fully responsible and considered an adult, so you have no control over what they do, yet they're generally not really making the greatest responsible decisions at those time periods. If the person is incapacitated, this is a really bad scenario for anyone to be put in. If they're receiving state or federal aid, they would lose those benefits as soon as they receive that lump sum from you that you're intending to be this great blessing, but now they've lost the benefits that they were receiving beforehand, and what you've left them is most likely not going to last them for their entire life. So at some point, they're going to have to run out of these funds you've left them and reapply for their benefits. But there's going to be a gap period where they will not have what you've left them any longer, or the benefits. And that gap period, they're going to be destitute and not have anything. So it's a really, really dangerous position to put someone in. And there are lots better ways to leave someone assets where they can still keep their benefits and be able to use what you've left them as a supplement to whatever they're already receiving. That's through a trust. So there are lots better ways to do that. What if the person you're leaving something to as a beneficiary is irresponsible? Again, another bad scenario. Those proceeds are most likely going to just be wasted on bad habits. So much better way to do that, where you can structure how something is left to somebody to make sure that it's being left to them in a responsible way, or being used in a responsible way. These are all reasons why the best way to avoid probate, instead of using these other methods, either that first method of joint tenancy, where it's just a temporary option and eventually it's going to go through probate anyway, it's just a stopgap, or the beneficiary option, where you've created all these other scenarios that are ending up either back in probate or with a bad situation for the person. All of these end up with these serious cons. That's why the trust plan is usually the recommended option of avoiding probate instead of these others. So one of the other things that should be included in an estate plan, in addition to the trust, some of which these options, by the way, some of these other things are a lot of times not even addressed in traditional firms or traditional estate plans. So let's go through these. We're going to actually go through each of these in detail so you know what things should be included in your plan. And let's just read through the list first. A record of tangible and intangible assets, guardianship designations for minor kids, durable power of attorney, advanced healthcare directive and living will, and a separate HIPAA authorization, and an organ donation addendum if you want to be an organ donor. Last will and testament, family trust, which is our revocable trust, and a legacy trust, which is an irrevocable trust. Let's go through each of these so that we understand what each of these is intending. So we actually, that record of tangible and intangible asset, we actually start our process creating an inventory of your assets, and that process of that record of tangible assets, even before you walk into your legacy planning session, you're probably going to be more organized than you've been before. And at a minimum, you're making sure that your family knows where to find your assets. And this is something you can do, by the way, on your own. It's a great place to start when you're doing estate planning. Making a list of all of your assets, a list of your bank accounts, life insurance, retirement accounts, investment accounts, any financial institutions that are holding all of these assets, and where these assets are, where they're being held. This is a really important exercise to do so that nothing gets lost. Again, there's $1.6 billion in the unclaimed properties accounts. Again, where money goes to die. You do not want your money ending up there. The final step in our process, so we kind of bookend our process this way, is that record of intangible assets. And that part of our process is, well, what we call our legacy interview. It's actually my favorite part. It's where you can record your values, family stories, and really create a legacy for the next generation. This part is key. It's something also you don't want forgotten. You don't want things that are key to who you are and your values and what's made you lost and forgotten. It's something that should be passed on to the next generation and should be memorialized and things like that. So that is also part of the estate plan that we make sure is recorded. Guardianship designations for minor kids. This is key. This is the thing that, one of the things that kept me up and broke me out of knives and all of those things when my son was little, and what really started me on the path to focusing on estate planning as the focus of my career. So if you have minor kids, kids who are under 18 or grandkids under 18, this topic is super important. And it's completely overlooked in most estate plans. So the way to think about this, what happens if you don't make it home as a parent? And don't even think about the fact that if you pass away, just think about if you're incapacitated. So say you're driving down the Beltway on date night and you get into a car accident and you end up in the hospital for 2-3 months, incapacitated, out of commission. Say your child is at home with a babysitter, or say they're old enough to be at home alone. And the police arrive at home, they somehow figure out that you have children, either by something in your wallet, photos, whatever. They figure out you have kids. They go to your home because they need to do a wellness check because you have kids at home and you're in the hospital and you can't talk, whatever it is. They go to your home. They find out your children are at home alone or child at home alone. They can't just leave your child at home alone, either with a minor babysitter or somebody that's not their parent or guardian. They have to take your child into protective custody. To me, 5 minutes in protective custody is 5 minutes too long in protective services. You want to make sure you have documentation in place that designates who you want in place, named as guardian for your minor kids. Normally, that person, the guardian of your child, is named in your will. But as we talked about, a will has to go through probate. Getting in front of a probate judge takes weeks to do. And this is something that is governed after you pass away. A will happens or goes through the probate process after you've passed away. The scenario I'm talking about right now is you're in the hospital. You have not passed away. You're just incapacitated. The will has nothing to do with that. It doesn't govern those kinds of designations. So big gap in the estate planning system. So in that scenario, you want to make sure you have other documents in place that are going to address who should be stepping into that role, and making sure that those people have those documents so that they can give that to authorities and have the ability to be able to take control of your kids and have them in their care without having to go through protective services, jumping through hoops, fighting with other family members. You want to be able to be designating who should have that care and have them be able to do that easily without any issues. And also having instructions for them. That's also the other big issue. Who are their doctors? What are their after-school activities? What are their allergies? All of those things need to be outlined and very detailed and thought of ahead of time, ahead of an emergency. So all of that, we call it our Kids Protection Plan, and we include it for all families that have minor kids. It's one of the key components of estate planning at my firm. So the other thing that you also should have in place, a durable power of attorney. that names an agent to handle financial decisions if you become incapacitated. So things like collecting your mail, paying your bills, filing your taxes, even taking care of pets. If you don't have that in place, what you're really asking is for your friends and family to step up. Somebody usually steps up to help out, but you're asking them honestly to act illegally, commit mail fraud, bank fraud, forgery, just to help you get things like your bills paid. You don't want to put someone in that kind of position when they're honestly helping you out. You want to make sure they have the legal authority to do anything that they need to do. And you want to make sure you're designating the right person to do that and not just having somebody say, I'll take care of it, and then making a huge mess of your situation. By the way, it is especially important for single individuals, especially if you don't have adult children, to have an estate plan in place, because there are no default people, so to speak, that the court would be able to appoint in those roles. So you need to be sure you're specifying who you want to handle your affairs so that the wrong person does not get appointed. A durable power of attorney is called durable because it survives your incapacity, but it does not survive your death. And that's why you still also need a will or a trust to govern what happens after you pass away. You also need an advanced healthcare directive, and this is the document that names an agent to handle your medical decisions if you become incapacitated. It's basically the medical version of the power of attorney. And you should also have a separate HIPAA authorization so that the agents that you name are able to get access to medical records if they need to be making decisions about your medical care if you're incapacitated. We saw the big need for this during the pandemic when families weren't admitted into the hospital, when patients were intubated, they couldn't communicate. Normally be able to see what was going on with somebody, or be able to ask a nice nurse if the doctors weren't telling you, if you didn't have paperwork, ask a nice nurse what was going on. But in the situation where during the pandemic where people were not even admitted to the hospital and you had to call in and give legal documentation as to who you were and why you were able to get any information, if you didn't have that documentation, you were left completely in the dark. It was a really scary situation for many families. And then at end of life, any interested person is able to weigh in on whether to keep someone on life support or not. And then you have this opposite situation where anyone in the family or friends can just say, no, I don't think they wanted this to happen. And then you have a whole situation where people, instead of supporting each other and coming together to support decisions, you have everyone kind of battling about what to do, which is, again, the worst possible time for things like that to be going on. You really want everyone coming together, supporting the one person who's supposed to be making the decision, and that decision is what you've already determined to have happen. They're just having the honor of carrying out your wishes that you've expressed ahead of time. You also want to have a living will in place, which is different than your last will and testament. The living will is what dictates what your end of life wishes are. So you can designate whether you want to be kept on life support or not, or for how long. All of those things, again, determined ahead of time, so your family doesn't have to feel guilty about what decisions they've made, worrying about it later. Did I do the right thing? They just have the honor of carrying out your wishes. And if you want to be an organ donor, being able to designate those wishes in the organ donation addendum as well. So let's get into trust. I feel like, did I skip a slide? Yes, I did. Last will and testament. Yeah, I did. Last will and testament. We can't skip the will, even though I was talking about the will as if we should skip it. You shouldn't skip the will. The will is still part of your estate plan. It names who gets what and who handles the distribution of your assets. So if you have children, again, that are minors, this is the document where you name that guardian, like I mentioned, for if you pass away. But again, this is after you've passed away, because if you're just incapacitated, you need separate documents to name who would govern, who would be guardian over your kids in that scenario. And the will would also specify after you passed away whether you want to be buried or cremated. That's where those designations are listed. But it's important to know that having a will does not prevent your estate from going through probate. It just makes sure that your wishes, rather than the state law, is controlling what happens in the probate of your estate. It's going through probate. The will has to go through probate in order to be administered. Otherwise, anyone can take any of your property and say, this will said I'm supposed to have this vehicle, give me this vehicle. It has to go through a legal court process in order to say, yes, this person's passed away, this is their death certificate, and this is the person named in the will who's supposed to govern what happens with their property. And now they're able to do that at this time. And here's the documentation saying they can do it. And that's a letter of administration, has the seal of the court. Now they're able to act. That whole process is probate. So that process is what the will has to go through in order to be administered. The trust that we talked about briefly is what prevents your estate from having to go through the probate. And it's administered totally differently. We'll talk about that now. Let's get into trust. And the reason that it's the recommended estate plan, it prevents a lot, well, pretty much all of the issues that we just went over, like probate and intestacy laws. But you really need to know about how they work, because so many people feel like trusts are for the rich or they're more than you need and things like that. And it's so not the case. A trust is simply created by a legal document called a trust agreement. What you're essentially doing when you create a trust is you're basically creating a separate legal entity, similar to like if you set up an LLC or a corporation, excuse me, or a corporation, excuse me. You're creating the separate entity and you're using this separate entity, your trust, to manage your assets during your life for your benefit, just like you're doing now, and then to efficiently distribute those assets after your death with much more specificity and protection for your beneficiaries, which is the goal. The trust, it can either be revocable or irrevocable. And whether it's revocable or irrevocable, the trust is going to have certain parties or people involved in making it work. Those people are going to be called the grantor or settlor, and that would be you. That's the person who creates the trust. And then you're also going to have a trustee, and that's the person who manages the trust and the trust assets. Think of that like the CEO of the corporation. In a revocable trust, that's also going to be you. The trustee can sell, they can refinance, anything that you could do with the property before it was put into the trust, you can do as trustee of the trust. If the trust is properly drafted, and that part is key, it has to be properly drafted in order to work. Your trust is also going to have a successor trustee, and that's the person who steps into the shoes of the initial trustee, which is you, after that initial trustee has died or become incapacitated. Finally, the trust is also going to have beneficiaries, and those are the people who receive the benefit of the trust assets. In a revocable trust, that's also going to be you. You benefit from your property while you're alive. You live in your house, you take money out of your bank accounts, all of the things that you normally would do. You also name beneficiaries after you've passed away for those assets, so that like your charities, kids, whomever you choose and how you choose would be able to inherit this after you're gone. And the how is one of the biggest differences between a trust and a will. You can be really specific and detailed about that how. But a trust agreement is honestly, it's going to be a stack of paper, a very expensive stack of paper, unless the trust is actually funded with your assets. So the trust is funded or made to work by retitling or assigning assets into the name of the trust. And this is key. It's one of the main things that you actually need to be looking for when you're getting a trust plan. You want to make sure that your attorney is going to help you with this crucial part, because we get so many families who come to us after they've had a trust for many years, and they just have this gnawing feeling that something's not working. I need this looked over. And the main thing is that it isn't working. Nothing has been funded into it. And we basically are redoing things because it literally is a stack of paper that has been doing nothing. And if they had passed away, everything would have gone through probate because nothing was actually funded into the trust. And at Adam's office, we make sure that this part is, we help you through the funding process to make sure that this part gets done. It's crucial. I always actually make sure I stop here and warn people even about doing this themselves, because that's the other thing that we also see is that we get a lot of clients who come in who have tried to do this themselves. And when you think about the fact that you have to transfer your actual assets into the name of this legal agreement, this trust agreement, if you're doing this yourself and you don't know what you don't know, you could have dotted every I, crossed every T, and just not know something that you have left out or done incorrectly and really have made a mess. And we see this all the time, especially in probate, where somebody has actually created a bigger mess for their families. It's a really dangerous thing to do, to actually transfer your house into the name of a document you're not sure works, transfer your bank accounts, your investment accounts, the things you've worked hard to build, into something that you're not sure actually works. You have to make sure this document has been drafted properly by a professional to transfer the actual assets into it, to make sure it's actually going to work and do the things that you're intending it to do to avoid probate for your family. And you haven't created a bigger mess than what you're trying to solve. Okay. The best way, I think, to think about revocable versus irrevocable trust is to think of a treasure chest. We call our family trust or we call a revocable trust our family trust, and think of that as an open chest. I actually purchased, I forgot about this. Should have had it more prominently out here so I could do this easier. I purchased a chest, so I had a little example. So think of the revocable family trust as a open chest. So this is open without a lock. And in this kind of trust, you're the grantor, you're the trustee, you're the beneficiary, you have complete control over it. You can put property into it, your house, bank accounts, personal property. You can take property out of it. If you want to give artwork to your family members early, you can take property, jewelry, house, whatever things you want to take out, you can take out, put in anytime, any way you want. You have complete control in and out of it at any time you want to. Because you have complete control, creditors who have a judgment against you can get access to this asset or to this trust as well through you. Say, for example, you take out an American Express card and you charge a bunch of money and you decide you're not going to pay American Express. Don't do this, but say you did that and American Express gets a judgment against you. Because you can reach in and out of this trust, the court can tell you to reach in that trust and pay American Express with the assets in there if they get a judgment against you. So it's not an asset protection trust. A revocable trust, because you can reach in and out, can be accessed by creditors through you. So it's used not for asset protection, but it's a huge benefit for probate protection. The probate court, anything you put inside of this chest, the probate court is going to completely ignore. It's totally protected from probate court. They ignore everything that you've put inside of here. So great asset tool, a great tool for probate protection, probate avoidance. It's also a perfect tool for estate planning. So what you put inside of here, you can direct how your beneficiary can access this and what to do once you've passed away, how it gets distributed out. So perfect tool for that purpose. Now, our legacy trust, which is an irrevocable trust, think of that also as a treasure chest, and you're going to put assets inside of it as well, your house, your bank accounts, same things, but you're going to close that chest and you're going to lock it and pretend there's a key. I didn't prepare this properly. Pretend there's a key. You're going to lock this chest and you're going to give the key to somebody else. Think of that as an adult child, probably the trustee of this trust. The key you're giving to that person is your trustee, and that trustee has control over this chest. They're the person who can reach in at any time and access the property that you put inside of this type of chest. So the benefit of this, Similar to what we talked about with the revocable trust, the probate court, again, is going to ignore anything that you've put inside of this chest. So it's great for probate planning, but it's also great for asset protection, because the American Express or creditor that had that judgment against you, they have no control over the person you gave that key to. And you don't have direct access to it. So they could tell you all day long to reach inside there, but you can't reach inside of there to get access to anything. You gave the key to somebody else and they have no control over that person. So it's perfect for asset protection. The other huge benefit, and the reason that we use a lot of irrevocable trust planning nowadays, is because of what I talked about earlier with long-term care. Medicaid will also, after the 5-year look back, completely ignore any assets that you have put inside of this type of trust. So it can appear as if you have that less than $2,500 in assets left in your possession because you put assets inside of this protected vehicle that only the trustee can access for you. So it's a huge protection, or great vehicle to use for that type of protection, to be able to protect assets from those types of things. So we use it all the time for that. Irrevocable trust can also be a great tool for things like using land trust. Techniques with land trust can be used for holding your residence or investment properties along with LLC structures. It can be used for privacy trust, so that people who may be trying to sue you to get to your property, they can't tell what you actually own by using these types of irrevocable trust vehicles. Offshore trust can be used as irrevocable trust to keep assets out of the reach and potential control of lawsuits and creditors. Irrevocable trust can also be used to reduce your estate size, so that you can eliminate or minimize estate taxes. So that's another, if you're in the higher range of estate sizes, it's also a great vehicle to be used for those purposes. Part of the decision about whether to use these kinds of trust and the higher level planning techniques depend on, number one, cost, because the budget size for this type of planning with irrevocable plans, it's a much more expensive planning option. But also with the Medicaid type of irrevocable trust, another consideration is whether you have or can qualify for long-term care insurance. If you don't have long-term care insurance or can't qualify for it, or if it's cost prohibitive, this type of trust can protect your assets from long-term care costs. So if you can afford long-term care insurance, you can use that instead of this type of trust. But if you can't afford it, if it's cost prohibitive, or you can no longer qualify for it, this type of trust is a huge benefit to be able to protect all of those assets from the $10,000 per month type of cost that long-term care would be. Another consideration is how much of the property you want to protect from things like creditors, lawsuits, or estate taxes. So those are all the types of things you would discuss with your attorney to make sure that whatever type of goal you have in your estate plan, the type of trust you're using is matching that type of goal. So as far as the benefits of a trust, and there are a bunch of them, avoiding probate is one of the biggest, which means a big savings of money to the tune of tens of thousands of dollars for most families, plus the saving of time and the elimination of that frustration and anxiety from dealing with the court and that court system after the loss of someone. That's one of the huge benefits of using a trust. With a trust, you can also be very detailed and creative about how to handle assets based on different family situations. One of my favorite reasons for using trust is that creative way that you can handle whatever is going on in a family situation. Also, if you have younger or maybe just less responsible beneficiaries, whether that's your kids or even if you don't have kids, but you're just leaving assets to nieces, nephews, godchildren, whomever it is, you can hold assets in trust and distribute them over time so that you avoid the issues that happen when you just have a will or you just do a payable on death or a beneficiary designation on an account without any structure or guidance. And then that young person inherits a chunk of money at 18, and after the loss of somebody important in their lives, and they're very vulnerable to the whims of their peers or social media for decision making. Not a good time for them to be in charge of lump sums of money. Instead, you can have a trustee that you select, hold those assets in trust and distribute for their needs, like healthcare, educational expenses, living expenses. And then at certain ages or certain stages, give them lump sums over time. What a lot of people do is a third distribution at age 25, and then another third at 30, and then another third at 35. But you can choose any age or any percentage at those different stages that you want. You can just decide the terms and be very creative about it, based on that child, based on that young person, and how you want to set it up. You can even add specific purposes they can use funds for, like higher education or purchasing a home, or starting a business or investing, so that it can be focused on your specific legacy priorities. So the trust can really be targeted to what you're trying to accomplish. You can also require that beneficiaries take a financial management course or speak with a financial advisor before receiving a lump sum distribution, if you know that you have a beneficiary that's not going to be great with money. You can even require things like having a beneficiary take a drug test or pass a series of drug tests over time before receiving a bequest. We had a client who, she was a single lady and her only beneficiary was her sister, who was actually in rehab at the time we were doing this client's plan. And this was the only person she wanted to leave anything to. So we had this very creative structure in place where her beneficiary was going to receive this over time, starting at, she had to pass 3 drug tests to even receive a distribution. The distribution started very small and it scaled up each month if she passed a drug test. And if she missed any of those drug tests or failed a drug test, it's scaled back down to a very small amount. And she had to pass the 3 successive drug tests again in order for it to keep increasing. So we were incentivizing the behavior that her sister wanted to see in her. So it was a really great plan, very creative. And you can do things like that with a trust, be very creative based on a family situation. It can also work, a trust, as an asset protection tool for adult beneficiaries. For example, if you have a beneficiary that's going through a divorce or a tax issue, or is being sued by someone, you can choose to, they can choose actually to leave what you're leaving them in your trust, so that after they have gone through that situation, it's passed, they can then take the lump sum out. Or they can just take smaller distributions each month that are not subject to the creditors, or annual distributions of smaller amounts, so that it's never subject to that third party taking it. So you can be just very creative and make sure that it's going where you want it to go and not ever taken by a creditor. If you're married and you have a concern for, after you pass away, your spouse choosing to remarry and having it be taken by a new spouse, or being distributed to someone other than your children, like the kids of that new marriage, you can actually require that your spouse, if they remarry, they have to have a prenuptial agreement that gets put in place in order for them to continue access to your half of the estate, so that it is always kept out of the name and control of the new spouse. And then your spouse can just blame the trust for the prenuptial agreement, but you make sure it's protected. And also the fact that you are avoiding probate and being really specific about distributions, a trust administration after you pass away does not have to be administered by an attorney. So it can take as little as a day, and it's so much less costly because of that. You don't have this cost of having to hire an attorney to administer an estate and having it be, taking months and years to go through this process. It can be done very quickly and easily and privately. And one of the things that the benefits of working with my firm, we try to make sure that our estate plans are really detailed in terms of the plan itself. Plus, we are here as a backup for your family members so that we are available if they need us, but we make sure that every plan has very thorough instructions so that they're able to follow that and have a roadmap that is laid out for them if anything happens to you. Another benefit of the trust is that if you have real estate in multiple states, for example, if you've inherited property in someplace like North Carolina, South Carolina, wherever, you can transfer ownership of all of those different properties into the name of your trust. That prevents probate in all of those multiple jurisdictions. So you've eliminated the need of hiring an attorney in each of those states for different probate in each of those states. It eliminates all of that and all of the costs associated with all of that. Also, if you're incapacitated during your lifetime, I don't know if you've ever heard of guardianship proceedings, adult guardianship, where if somebody is incapacitated and they don't have a power of attorney or an advance directive in place, you have to go to court in order to get approval from the court to take over managing their estate, their affairs for them. It's a very costly, embarrassing process for the person who's needing guardianship. Not fun. Family members can sometimes get at each other for it. It's not a good situation. Anytime you have to go to court, it's not a good situation. But that can be completely avoided because your trust has already stated who should be managing your affairs if you become incapacitated. You set that up already in your trust as a successor trustee, and their role is already outlined in your trust, what they're supposed to do. Take care of you with those trust assets. It's already outlined and in your trust agreement. So you've eliminated the need for that court proceeding altogether. So the trust covers so many bases in terms of benefits and why I love doing trust planning so much. So we shared a ton of information. I know we get through a lot of information very quickly in these workshops, and I know it is a lot to digest and about all of these documents and the right terminology and all of that, but I do always like to shift gears back to what truly matters, hands down, at the end of the day. When it comes to your estate plan, absolutely the legal documents matter. You definitely need tailored and personalized legal documents, but ultimately at the end of the day, your family will appreciate that you did an estate plan. You created the roadmap that they can follow, and one that incorporates something that they can remember you by. But you really want your legacy to be that you actually did it. What's great is that estate planning, the process itself, actually brings you clarity and relief around that, those financial and legal decisions that you have wanted to make and may not have made before, and it really helps you to feel not just more responsible, but more at peace and assured, having settled those kinds of important decisions and having put things in order in the way that you want, and you want to make sure that are done the way that you want. So where do you start? Preparing that list of assets, gathering recent account statements. That's always a great place to start. In terms of getting your estate plan in order, deciding who you want in important roles and gathering their contact information is the second place. So the part of our process involves an online questionnaire where you'll be able to plug in all of that information, and you can actually then get that, the list of what you plugged in, exported so that you would then have that as a useful organizational tool. That in and of itself is something that's worth having because it creates that organization for you, and that list, that inventory we were talking about of the things that your family needs in the first place. What I always recommend is thinking about these things ahead of time. The assets, gathering that ahead of time, and thinking about who you want in those important roles ahead of time, and gathering their contact information ahead of even sitting down to do the questionnaire. Because when you do that, you can finish it really quickly. It takes like 15 to 20 minutes to finish the questionnaire once you have those pieces of information in front of you, the contact information for those people that you want in the important roles in your plan. Other things you need to do to start off is thinking about how you want your beneficiaries to receive what you leave them, or any special instructions that you have for your beneficiaries. Thinking that through so that by the time you come in, you really have some thoughts about how you would want things to happen. That way we can really help you with things that are either that you haven't thought of before, or other things you can do in addition to that, ways you may not have thought of handling situations. But if you've thought of some things in advance of that and helping us being able to help you structure that is always a real benefit. And then scheduling your complimentary consultation so that you actually can get this done. So here is our process to get your plan in place. The initial meeting is called the Legacy Planning Session. It's where you meet with us at our office, or you can do it via video conference if you want. Before your planning session, you complete that online questionnaire I mentioned. It's a very easy and secure way to provide your information, the information about you, your family, and your assets, and so that we can review that in advance of your meeting. The attorneys prepare all of that before you even come in, so we know all about you and how to focus your planning session on your goals. So at your planning session, we hit the ground running with all that information. We go over all of your questions and your family situation and your goals and what your current situation looks like for your loved ones if anything happened to you. We identify some solutions to address any issues we find with that current situation, and then you choose your desired estate plan to fix any of those issues that we identify. We then start designing your plan together that day. After that initial meeting, we then prepare your plan and we send you drafts to review. That part is important. You should never be just signing off on something you've never looked at. In about 4 weeks from that initial planning session, we meet again for your signing ceremony. And that can also be done via video conference, by the way, if you need it to. But usually you come into the office and you do your signing ceremony, and that is when your plan is legally in place. This is a big day. You can toast to champagne that day if you'd like, but everything that you've expressed as your wishes and your desires, your goals in your for your estate and for your family is in your legal documents, and you have your family protected at that point once you have signed off on that. And that is a huge relief. Families leave with literally, it looks like the weight of the world off of their shoulders. It's huge for us to see that in person, and for our families who we do planning for, it is a huge relief. And then we focus on our favorite part or aspect of the plan, which is your legacy interview, where we record via video your insights, your values, and your stories for the next generation. That part is so fun. We also prepare your asset transfer documents for you. And we mail and fax those out. Any of them that can be sent to the financial institutions directly, we handle for you. And we prepare instructions for any of the financial institutions that are going to want to have you go in person or complete anything online. We prepare instructions for you. So we make sure all of the asset transfers get done. If you're not tech savvy, you can also set up time to come in and have us help you with the help of our funding assistant, who will handle walking you through literally funding any of those things online. If you want us to do that with you, we will help do that. We want to make sure this gets done. We also handle the transfer of the deed to your house into the name of your trust. And this entire process is about a 4-week process to get your estate plan in place. And we do the heavy lifting for you all along the way to make this process as efficient and as easy as possible to actually get accomplished, not just talk about getting accomplished. And all of that is included in our normal planning process because, again, we want to make sure this gets done properly. At your signing ceremony, we also go over our membership program, and that is something you can sign up for if you choose to, where you can keep your plan updated. We do highly recommend you do that. And that is something you can sign up for if you choose to. So our main packages are broken into 3 main estate plans, and that's based on your particular family's needs that you can choose from. The first one is the will plan. So this plan is for families that do not really have assets that would have to go through probate. Like if you're renting your home, but you do still want to guarantee that your minor children are going to be cared for by the people you choose, and that your healthcare wishes are turned into directives, that your loved ones are able to access things like your utilities, cell phones, using that durable power of attorney if you become incapacitated. So it has those agency type documents. And this plan includes your last will and testament. And again, those healthcare directives, the power of attorney. So you know that you're legally taken care of if anything happens in that regard. And it definitely has that complete kids protection plan with the guardianship documents that ensures that your kids are always raised by the people you want in the way you want, never taken out of your home by authorities if you're incapacitated. This plan, again, it goes through probate. So you do not do this plan if you have assets like a home or bank accounts that have any significant amount in it. This is for somebody who has, like, you get paid, and what you get paid basically goes to all your bills, and you're probably renting your home. So very basic plan. We even have for college students an even more basic plan than this, but you're thinking something along the line of you're just out of school type of situation. That would be what the will plan would be for. Then you have the trust plan. This is our family trust plan. This is a step up from the will plan. And this is what most of our families choose and need. And this is if you have assets, because you don't want anything, if you have assets, you don't want any of that going through probate. So you do not want the will plan if you have assets, you want a trust. So this plan is if you want the peace of mind of knowing that your loved ones would stay out of court and out of conflict if something happened to you. And you also can opt to add in things like beneficiary, asset protection. If you want to make sure beneficiaries are, if they have like lawsuits or ex-spouses or creditors, and you want to protect from any of those types of things, you can add in asset protection like we talked about earlier. And your trust plan also includes a will. So your will still comes with a trust, and the power of attorney and advance directive. And again, the peace of mind of knowing that your affairs are kept private and out of court and out of conflict. And that using this trust to hold and distribute your assets like your house, make sure that that gets done in that way outside of any kind of court process. And remember, with our plans, we prepare the asset transfer documents for you and help you handle all the funding of your assets. We also handle the transfer of the deed to your house into the name of the trust. And then we have the legacy plan. And this is for families wanting to do Medicaid planning with an irrevocable legacy trust to protect assets from nursing home costs. And again, those can average like $10,000 per month. In the legacy trust plan, you again get all of the benefits of the will plan, plus the irrevocable legacy trust. So you're getting a will, power of attorney, advance healthcare directive, plus the irrevocable legacy trust, and instructions for you and for your trustee and tax professionals and financial advisors about how the irrevocable trust works. And just like in the revocable family trust, we transfer the deed to your primary residence and prepare all of your asset transfer documents and help you get your assets transferred into the trust. So in terms of the investment in the estate plans, peace of mind, the relationship with an attorney that will last your lifetime and to be here for you during your life and for your family when you can't be. The investment for that legacy plan, that's the irrevocable trust plan for Medicaid planning, is $6,000 for singles and $7,500 for couples. For the revocable family trust, it's $4,500 for singles and $6,000 for couples. And for the will plan, it's $2,500 for singles and $3,500 for couples. In the trust plans, you can also add in, like I mentioned, asset protection for your beneficiaries. And in that revocable trust plan, you can also add in things like the protection for spouses if you want to do that prenuptial type of planning and things like that. Either of those asset protection or spousal protection options are an additional $1,000 if you want to build those additional things into those plans. And we, of course, have other options that you can discuss with the estate planning attorney. You can go over anything that is based on your particular family situation that you want to add in or discuss with the attorney. Our goal really is to help you choose what's going to be most affordable and effective for you to accomplish what your goals are in the plan. So you would go over any of those questions with the attorney. Payment is usually done 50% at the first meeting and the balance at your signing ceremony in that 4-week time frame. If you're paying by check or ACH withdrawal, which is our preferred payment method. You can also pay in installments over time, though, if you need to. And we then just push out your signing ceremony from our normal 4-week time frame to whenever your final payment is going to be scheduled. So what some of our clients actually do to make sure they can still get this done as quickly as possible is to put this on like a credit card so they can still get like their points and so forth, and then take as long as they need to with paying that off on the card. And that way they can still stick to that 4-week time frame for getting their plan signed. So all of those options are available. So hopefully you figured out what the best estate plan is. That, of course, by now you know is the estate plan that actually gets created. The biggest danger to really your legacy and to your family's well-being is procrastination. And we have found that over the years. That's why we do all we can to keep you moving towards that goal of getting your plan in place. If you raise your hand to us and say you want to get estate planning done, all of our systems are set up to keep you moving towards that goal. We also want to make sure that it's personalized for your specific situation, and it's really capturing your legacy and what's most important to you. And also that your plan, when it's in place, it gives you peace of mind. It should give you and your family peace of mind, knowing that you've protected what you've been working hard to build all of these years. That really should be the end product, is that peace of mind. So what is next? Well, we host these workshops, number one, because this information is so needed in our community, but number two, to make it easy for you to get a plan in place for yourself and for the people that you love. All of our systems, again, are designed to help you get this done and to make it as easy as possible to keep you moving forward. So in service to that, if you're ready to get this taken care of and get the next steps done, we're giving you a golden ticket to support you doing that. Normally, our legacy planning sessions with one of our attorneys is $750, but I am waiving that for our workshop attendees. So if you are hearing me say this, you do not have to pay for your legacy planning session. Also, like I mentioned, we know the number one reason for people failing to plan is procrastination. So I'm not only giving you that planning session for free, but also a $250 incentive to not procrastinate any longer, because I know this is something you want to do for your family anyway. So that $250 would be off of your estate plan. And our attorneys always ask me to be really clear about how the discounts work. So to repeat, that's not $750 off of your estate plan. That's a complimentary legacy planning session. That meeting fee of $750 is being waived for any workshop attendees. And then the discount off of your estate plan is $250. So to take advantage of the discounts, and again, this is to incentivize action, you would need to book your legacy planning session today and then not reschedule it after next week. So you have a full week to check your schedule and reschedule it if you need to during this week to be able to take advantage of the discounts. But you need to be booked today and then confirmed by next week to be able to get the free session and the $250 off of your estate plan in that session. And that's in service of keeping you moving toward your goal, simple incentive to not put off planning and to help make it as easy and affordable for you as possible. And once you sign up for that session, we do need your online questionnaire completed at least 3 days before your meeting so that the attorney is able to prepare for that session and hit the ground running with you in that session. So to set up your complimentary legacy planning session, we have a link you can click on. I will share that in the chat. I think you should get that. And there's also a QR code you can scan. Our online calendar does fill up really quickly though when we do these workshops. So you can also email us if the online calendar is full when you're trying to do this. You can email with your name and cell phone number to our email which is support@adamslawoffice.net, and just put workshop golden ticket in the subject, and we will know that you are signing up for a planning session within that time period. So you would be good to go with your discounts. You can also call our office at 301-805-5892 to speak with our estate planning coordinator during business hours, or you can leave a message and we will call you back during business hours. Also, if you have friends or family members who would benefit from this information, feel free to pass along our information. Also, if you're a member of a club or association, we also do private seminars and workshops, and you can call us to set those up with us as well. And as promised, I want to give some time to answer any questions that you might have posted in the chat. Usually we have at least 1 or 2 questions. Everyone is usually overwhelmed by this point, but let's see if any questions are coming through. Okay. Okay. Yep. If I move, will the trust still be effective? Yes. Yes. So if you create a trust with us, we prepare all of our trust in such a way that they are self-proving in every state. Plus, every state in the U.S. has reciprocity rules. So if a trust is validly created in one state, it is good throughout the U.S. And again, we prepare them in such a way that they are self-proving in every state, so you won't even have to do anything additional in any state that you move to. It will be good. The only thing I ever recommend when any of our clients move out of state is that if they open a bank account in another state that they move to, and that is a bank that's not national, it's local, for example, like a credit union for that particular state, they should check with a local attorney to see if that state has a statutory power of attorney law in place. Because if it does, they may want to have a second power of attorney that they create for that state. Because usually banks, in order to, they're not required to accept a power of attorney unless it states statutory power of attorney if there's a statutory power of attorney law in place. So in order for that bank to be required, they may need to do that one additional thing, and those are usually easy to do in that particular state. If they never open that additional bank account, then they don't need to do anything additional. They would have the power of attorney we prepared, and the trust is certainly valid. So nothing else would need to be done. The one thing they should do is if they purchase the property in another state, put that property in the trust that we've already created, because any additional assets you acquire after we fund your trust should be added to your trust. And that's also why we always recommend joining membership, so that anything new that happens in life changes, and you want to make sure you're keeping up with any changes in your plan, in your life, and that your trust is keeping up with that. So yeah, that is one of the things we always recommend. Let's see, any additional questions? Oh, yep, that is with the last thing I just said. So the next question that came up was about membership. And yes, so I do recommend membership, and it is basically because of the fact that life changes. We recommend you review your plan at least annually, and especially if you have young children, or the agents that you've named are fairly young and they may be mobile because they may be moving around, and you want to make sure that the plan is updated with any changes of address for them. If you have young children, often it means changes will be happening in how distributions are handled. Things like that will need to be adjusted. Changes in your guardianship instructions will need to be made probably. So any of those things, you want your plan to be as fluid as your life is and changing with any changes in your life. And membership allows you to do that on an annual basis for free. It's included in your membership. We also include an annual update to legacy interviews, so you can build a library of your legacy interviews, which I think is really cool to do. I never want you to think of legacy interviews as something you should put on the shelf and not have family members listen to until after you're gone. It really should be one of those living, breathing things that you kind of share at special occasions, so that it really can transform how you interact with family members. And I hear that all the time from our clients. It happened with me when I did my legacy interview. It changes how you interact with the person that you've just verbalized these really important things about. Like one of our legacy questions is, what are the favorite things about the person, about your child, for example? And just verbalizing those things out loud about somebody changes how you interact with them. It's a really powerful thing. So those kinds of things, being able to create that as a library of thoughts and values and stories and things like that, and being able to share it at special occasions is something that is powerful. And if you're one of those people who are not comfortable with, videos and things like that, you can do things like that by even writing letters. It's something that is just such a powerful thing when somebody has something that personal from you. It's the thing that people hold on to. I always say no one is going to put your trust or your will on their nightstand to remember you by. These are the things that they will hold on to forever, those personal letters or videos or personal things that you have left. So it's really the parts that make a legacy plan really lasting and impactful. So membership can be a key part of that because it allows you to update things on an annual basis and keep them fresh and flowing with what changes are happening in your life. Okay, let's see if we can do one more question. Okay, yes. So we are licensed in Maryland and in DC right now. If you have family members or if you're located outside of the state of Maryland and DC, then you can contact our office. We can send you links to like-minded firms that we can refer you to, but those are the states where we're licensed right now. And obviously, as that changes, once you contact us, we can let you know if we're able to prepare plans elsewhere as well. All right. Well, thank you so much. Hopefully this was helpful information for you. And I hope that Adams Law Office will have the honor of helping you create a legacy. And thank you so much for joining me.